You saw senior Supreme Court advocate Arima Sundaram explain why he felt that Arvind Kejriwal was given bail in the right fashion and that this was a just and proper order. However, the Enforcement Directorate was arguing very strongly through the Solicitor General that this would set a bad precedent because there are many other leaders in jail who will now ask for bail on exactly the same basis. Which side holds more water? For this, I'm now joined for a legal perspective by Mahesh Jethmalani, who's been with the BJP, is a senior advocate and a legal eagle himself. Arima Sundaram arguing on India Today tried to build the case why this is an exceptional order because he's been given interim bail. There's a big election happening. He needs to have the right to be able to go out and campaign, and therefore there's nothing amiss with what the Supreme Court has done. Is that your sense as well, or do you think, Mr. Jethmalani, this could set a very bad precedent?
Well, basically, lawyer first and politician second, Rahul, right? Bail should really be granted on bail jurisprudence, right? Extraneous factors like the ongoing elections, etc., ought not to weigh. Frankly, there's no precedent for this, right? So I have to say this is an unusual order.
No, so he says in the High Court case of Sanjeev Khanna, this is not unprecedented in the manner of interim bail. It's unprecedented because of it's an election, but not unprecedented otherwise. Under different circumstances in the same matter, interim bail has been given.
Listen, bail has been given, interim bail has been given in many cases.
Correct.
Right? Interim bail is not the issue. The issue is the ground on which it is given. There's a single ground, and that is the ongoing election ground. That's all. And, in the past, precedents actually go on the other way. Look at Jayalalitha's case. You look at Lalu's case, right? They were refused interim bail for the brief period of the elections. So the precedents go the other way. And not on that, Rahul, there's something more serious. This is a man who avoided 9 summons from October 23, right? 9 ED summons were willfully disobeyed. And he treated them with contempt. After refusing 9 summonses, he then dared the ED to arrest him. They arrested him. So the signaling is wrong. The messaging in this case particularly is wrong, right? I have no problem. I would not even blink an eyelid, right? If somebody said, give him some time to go for bail, there may be no precedent for it, but it's, all judicial discretion is really an appeal to judicial conscience. So if the present bench felt that, let him go for his elections in 3 weeks, we'll hem it with conditions, right? And he'll be back in jail after 3 weeks, right? And then we'll decide that the petition which they were hearing in which the bail was done. All that is fine. But this man has a history in this particular matter, right? 9 summonses and a dare.
No, but he will come back
to
Tihar on the 1st of June. It's part of his bail conditions.
What is part of his bail conditions?
The fact that he'll come back after the 1st June campaign ends is part of the interim bail condition. So he has no option in that.
Yes, of course. So that's all good. I said it's hemmed in with good conditions. But I'm saying the messaging is wrong only for the reason of this man's attitude. He flagrantly disobeyed the law. If you don't attend the summons, right? 9 times. It is contumacious conduct which normally disentitles you to bail.
But the Supreme Court also said that this is quite exceptional because elections happen only once in 5 years, that he should be allowed to go out and campaign. Does this then set a precedent? Because I was seeing that Amrit Pal Singh and the Solicitor General referred to that, the Khalistani separatist who's in Dibrugarh jail on NSA charges. He's saying, I'm also fighting as an independent from Khadur. I also want bail. Now, when this goes before the Supreme Court bench, if it's the same bench or another bench, then how do they look at a case like that? He's not been convicted either.
Yeah, no. So look, now that's the problem. The other issue is it opens floodgates in the kind of cases which we just mentioned. It does. And the Supreme Court, they're going to have to make fine distinctions in each case now, right? When you exercise jurisdiction, right, discretion, you have to look at what is the outcome, what are the consequences of exercising the discretion and I think both his past conduct and the floodgates argument were good reasons for not doing it. And I'm not grudging Kejriwal bail, right? And the Supreme Court believes that elections is the lifeblood, like we all do, of a democracy. Fair enough, but then it should apply equally across the board to everybody, right? If Soren comes knocking at the Supreme Court's door tomorrow, he should be released on bail. What's the difference?
So how would you look at the difference between the Soren case and this? Because the Supreme Court, in the proceedings that were going on, said he is not a habitual offender, that he could have been arrested earlier, you've arrested him in the election cycle. How would you, if you were in the court, compare this case with the Soren case?
Well, I would say Soren's case stands on a better footing because he didn't disobey 9 summons. He didn't disobey 9 summons. You know, it's an offense to disobey a summon by a public officer acting in the course of his duty. It's an offense in itself.
Okay, so you said you'll speak as a lawyer first, politician second. Now, if you put on your politician hat, 2 weeks to go, election campaign, I'd speak. This is not good news for the BJP. The BJP tried very hard through the Solicitor General to avoid this. Fact is, he is a pugnacious campaigner. He's often gotten under the skin of the BJP leadership. He's now out, not completely unbridled and free to do what he wants, but he will have some restrictions. But as far as politics goes, he'll punch as hard as he can.
But nothing wrong with that. He was punching even from within jail. He was punching at that. His statements were coming out every day from within jail. So, that's good. Look, politically, I think, right, if it wasn't for his past conduct, etc., and if it wasn't for the absence of any precedent, and in fact, precedents to the contrary, I would say, all right, it's 3 weeks, elections, lifeblood of democracy, 18th Lok Sabha elections, everything the Supreme Court said. But there's a history and there's a consequence of what you've said, what you've done in this case, right? I think Soren's case is better given the conduct of Arvind Kejriwal, which Soren didn't indulge in.
Okay, we'll leave it over there. I know that I pulled you out of dinner, so I won't hold you any longer. Thank you very much, Mahesh Jethmalani, for joining me.
Thank you so much.